All right, did you forget about the court hearing this morning? Did you forget about the court hearing this morning, Mr. Hayes?
No, I didn't have the number, so I had just texted Emily and she gave it to me.
Okay, are you driving the car right now?
Oh, I just stopped.
Okay, tell us when you have stopped and pulled over. You're in court, sir. Come on.
I'm in court. I'm ready.
Okay, but you're about 25 minutes late.
I'm sorry.
All right. All right, Mr. Guimond, we'll have you talk to Mr. Walker. It's a very short-term marriage, Mr. Hayes.
Okay.
You lived together as husband and wife for like 3 months, and Mr. Guimond indicates there's really nothing in that issue. There's no property to be divided. There's no joint debts. Would you agree?
Yes.
You got 2 children. The only issue is custody and parenting time, and presumably you've been working out a parenting time schedule. Of course, can have you talk with Mr. Guimond in front of the court just real briefly? If you can come to an agreement today, we can finalize this matter. You can move forward in your life.
Well, may I speak?
Yes.
Well, I would normally agree with this today, but there's so much going on right now, and I don't think it's a good time for Emily because her dad just died last week from stage 4 cancer. Her mom is on hospice, and a divorce will probably.
Everyone's here. All right, everyone's here, Mr. Guimond. So we're going to, Mr. Hayes, we're going to have you talk with Mr. Guimond and Emily. Let's see if we can do this quickly and have you talk with Mr. Walker from the front of the court. We're going to put you in a breakout room. It should take no more than 5 minutes.
Okay.
Thank you, Your Honor.
Mr. Hayes, can you take your hat off? You're in court, please. Back on the record on this matter, Ms. Hayes, are you still present on audio?
Yes, I am.
Okay, Mr. Hayes has appeared. Mr. Hayes, now you have informed Mr. Walker you want to talk to an attorney. Why don't you tell the court that when you first came in, saying, Judge, I want to talk to an attorney. You're wasting everyone's time this morning, Mr. Hayes. You're playing games. So how much time do you need to which to consult an attorney? A couple weeks?
Yep.
And you were served as divorce claim in January. Why do you wait till the 11th hour to talk to an attorney? You've known about this since January.
I don't know. Yeah.
I don't know either. Okay, we'll give you an adjournment. One last adjournment, Mr. Hayes. And if you don't even hire the attorney, at least consult an attorney. I'm not sure what there's to consult on. There's no property to be divided, no joint debts, no spousal support. Simply a matter of just custody and parenting time. In front of the court's already made a recommendation regarding child support. And you've not been in court, so presumably whatever parenting time schedule you have been exercising has worked for you and Emily and the children. But we'll give you a chance to talk to an attorney. And so we'll mail you a notice for a continued pretrial conference. Mr. Hayes, are your address still 4?
No, I stay at 4. Me and Emily still live together.
Oh. Okay. Okay. So make a note. We're going to give you another date and we'll mail you a notice. How about June 7th at 9 a.m.? Mr. Guimond, will that work with your schedule?
Yes, Your Honor.
All right. So we'll mail out notice on a continued pretrial conference June 7th at 9 a.m. So make sure you appear at that time, not 9:30, Mr. Hayes, but 9 a.m., please.
Yes.
And if you contact an attorney, you can always reach out to Mr. Guimond. Maybe he can put together a proposed consent judgment divorce.
I don't like him.
Divorce on that date. I'm sorry.
I don't like him. I don't like him.
Okay, you don't have to like him. You don't need to like the court. We all have a job here to do. And if Emily wants a divorce, I mean, she's entitled to it. I'm just trying to help you through this and see what issues that need to be addressed to assist, particularly the children that you brought into this world. In any event, so we'll see you back on June 7th at 9 a.m.
All right, thank you, sir.
Thank you, Your Honor.
You're welcome. Okay. For the record, this matter is before the court for a pretrial conference, the same being conducted via Zoom. Actually, I guess it's a continued pretrial conference. The original pretrial was scheduled for May 3rd. I don't recall why this was adjourned.
If I may, Your Honor.
So Mr. Hayes requested a continuance. Is that correct? When we were last year?
Yes.
Right. For the record, this is before the court for pretrial. It's being conducted via Zoom. President is Attorney Alex Guimond. represent the plaintiff. The plaintiff is not now present, but apparently she had some funerals to attend to. She's dealing with some personal issues, so she's not present, which is understandable, and that's fine, Mr. Bowman. But I see Mr. Hayes requested continuance so you can consult with an attorney. Is that the reason for the continuance?
Yes.
Okay. All right, and obviously you've had that opportunity. We have a pretty short-term marriage here. Do we need a formal mediation date, Mr. Goldman? Have you had a chance to talk to Mr. Hayes this morning?
I think mediation would be helpful.
Okay. Right, so Mr. Hayes, what the court's going to do is schedule us for mediation. It's not binding, but you have a certified trained mediator. There's no cost of mediator. That mediator, their job is to facilitate, to help the parties find some middle ground to reach their own agreement.
Yes.
Okay.
Okay.
So I have some dates here, Mr. Goldman. Now, we don't need your client here to schedule this. Unfortunately, we don't have any. Soonest date we have is June 13th. Is that too soon? Yeah, that's.
It's not too soon. I'm just not free that day.
We're looking to July. How about July 18th?
I can do the morning.
July 18th at 1:30. I'm sorry, yes, at 8:30. That's a Thursday morning, 8:30, July 18th. That works with you, Mr. Goldman?
Yes, Your Honor.
Okay, Mr. Hayes,
Yes.
July 18th at 8:30. There'll be a Zoom mediation. Will that work with your schedule?
Yes, sir. Yes.
Okay, Mr. Hayes, let's make sure we can verify your address. You are.
Yes, sir.
And you, Ms. Hayes, are still living together, correct?
Yes.
All right, but it's a short-term marriage of 3 months. Mr.
Well,
Goldman, what do you understand to be the issues? Is there real estate that's owned that needs to be divided?
No, Your Honor. I think it's primarily going to be custody and parenting time.
Okay. Is there any joint debts that need to be divided?
Not that I'm aware of.
Okay, so you'd agree, Mr. Hayes, that there's no real estate to be divided, no joint debts to be divided?
Yes. No, yeah. Nothing to be divided.
And hopefully you can work out division of personal property.
There is none.
Let's see, parenting time, and we have 2 children. Oh, they're older children, 17 and 15.
Yeah.
I would think custody parenting time should not be much of an issue. I mean, the children have significant voices in terms of what parent they want to live with at that age.
I agree.
Correct.
So the court's noting that for the record. All right, so the court mailed out notice of a mediation with Mr. Walker in front of the court July 18th at 8:30 with the parties to appear for a continued pretrial conference thereafter.
Very good.
Okay.
Mr. Hayes, do you have any questions this morning?
No, sir.
Okay, of course, you can always talk and make an appointment. You can consult an attorney and pay a consultation fee. You don't have to hire the attorney, but you can always consult an attorney. You got plenty of time to do that.
Okay, I will.
If you have any questions.
Yeah, Your Honor, when you said a mediation, what did you mean by that?
Well, you and your wife and Mr. Goldman are going to meet with this mediator, and the mediator is going to ask, okay, what are the issues, and try to find some middle ground to help you find your own agreement.
Oh, okay. Okay. Yeah, that's fine.
But it appears to the court, these are not 2- and 3-year-old children. They're going to be soon adults.
Yeah. One of them will.
Your
It'll be
daughter-
18 in September.
Well, she's on her own. So this court has no jurisdiction over her once she turns 18. She can do
Right.
whatever she wants.
Correct.
So there's no reason why the 2 of you should not have joint legal custody. So you share equally any major decision concerning the welfare. It's just a matter of parenting time. But these children at their age have a lot of say in that. I mean, if you and your wife cannot agree, then the court will make a decision. But at that age, I'm gonna interview the children. If they say they want to live with mom, that's what's gonna happen. I'm just telling you that. That's the reality. The children at that age have significant voice in their placement.
I understand.
So you're still gonna be their father, even though they're divorced, you're still gonna be their father.
Yes.
And the courts, we don't need to get hung up on physical custody, just joint legal and in parenting time. And the parent, those children at that age have significant say in when that parenting time is. They've got their own activities, I'm sure, if they're involved in extracurriculars and after school and so forth. So their schedule drives a lot of that. Once again, are you employed, Mr. Hayes?
Oh, yes, I'm employed. I'm an employee at the same job for 15 years.
Okay, well, Mr. Hayes, there is a filing fee that needs to be paid. Ms. Hayes, public assistance, the filing fee is $255, so make a note of that. And the courts will order that you pay that on or before the day we come back from mediation.
Okay.
July 18th. So it's a $255. You can call the clerk's office, second floor. You pay that with a credit card, but again, they're going to charge you a fee for that. You're best off just coming into the county clerk's office when you have the $255. Bring in the paperwork, give them the case number. I'm here to pay the filing fee. They will not take installment payments. You got to pay one lump sum of $255.
Okay.
Okay, so please take care of that between now and July 18th. This court's going to address that when you come back. So I would appreciate your cooperation getting that taken care of before then. And the court will mail
Yes,
you
sir.
notice with Mr. Walker's. Will be a Zoom mediation, July 18th at 1:30.
Okay. 8:30, right?
Right. Anything further, Mr. Goldman, this morning?
No, but Mr. Hayes just asked to clarify the time, that it's 8:30 a.m.
Yes, 8:30 a.m., Mr. Hayes.
Okay, thank you.
Okay.
Nothing further, Your
Right.
Honor.
We'll see you then.
Thank you.
All right.
Okay,
Have a good day. Bye.
you as well. Mr. Hayes, you were previously ordered to pay the $255 filing fee prior to today's mediation. Did you pay that this morning?
No, I didn't.
Okay, can you pay that by the end of the day?
Well, I don't get paid till the end of the day.
Well, you've not been paid since we were in court back on June 7th?
Yes, I've been paid since then, but it totally slipped my mind, until I was reminded of it. So I thought about this week.
Well, when can that be paid?
Can I get a week?
Sure. Do you want, how about July 31st?
Yes, that's fine.
It's a week and a half. It's the last business day of this month. Make a note. You got a piece of paper and pen?
Yes, I do. I have it right here. July 31st.
We don't want to be issuing bench warrants, Mr. Hayes, so please take care of that. And Mr. Goldman, can you please make a note if in fact there's an agreement with the parties, if you could please put it in the judgment that Mr. Hayes is ordered to pay the $255 filing fee on or before July 31st, 2024, please. I'm sorry, Mr. Goldman, I don't know if you're muted. We couldn't hear you at all.
Okay.
Mr. Goldman?
Yes, Your Honor. I will put that filing fee provision in the judgment.
Thank you. The court has been informed by Mr. Walker that the parties have reached their own agreement this morning. Is that correct, Mr. Goldman?
Yes, Your Honor.
All right, is that correct, Mr. Hayes?
Yes, sir.
All right, without question, the best resolution of matters of this nature is one in which you participate and agree upon. Far better off than having a trial in this court to make those decisions. So the court's going to have Mr. Goldman state on the record what he understands to be your agreement. After he does so, I'm going to turn to you and ask you whether or not he accurately stated your agreement. Understood?
Yes.
All right, yeah, Mr. Hayes. All right,
Yes,
Mr.
sir.
Goldman, if you could please state what you understand to be the parties' agreement, please.
The parties will share joint legal and joint physical custody of their two minor children. There will be reasonable and liberal parenting time arranged between the parties. The child support order dated April 4th, 2024 will remain in effect except for the fact that the effective date will be July 1st instead of February 1st. Each party will keep the property currently in their possession, property or debts in their possession. Mrs. Carrie Hayes is awarded immediate exclusive use of the home at Monroe. Both parties are prohibited from entering onto the property where the other party lives. Both parties are barred from requesting spousal support. So neither is receiving spousal support at this time. Both are barred from requesting in the future. And that is and Mr. Hayes will pay the $255 filing fee by July 31st.
Thank you. Pension benefits. Are there any pension benefits to be divided?
No, Your Honor.
Okay. Now, try the real estate. That is a plaintiff was awarded exclusive possession. Do they own the real estate?
It's a premarital separate property titled exclusively in Mrs. Carrie Hayes' name.
Okay, so that property is awarded to her free and clear of any interest on the part of Mr. Hayes.
Yes, thank you for reminding me.
All right, and there's no joint debt on there, correct?
Correct.
All right. All right, Mr. Hayes. First of all, can you state your name and current mailing address for the record, Mr. Hayes?
Yes, my name is Alex Hayes. My current mailing address
Did
is
Mr. Guimond accurately state your agreement this morning?
Yes.
Okay. All right, so Mr. and Mrs. Hayes, can you both please raise your right hand to be sworn, please?
And did we file for divorce on December 20th? Or did you file for divorce on December 20th, 2023?
Yes, I did.
At that time, had you lived in Michigan for 6 months?
Yes.
Had you lived in Monroe County for 10 days?
Yes.
And were you and Mr. Hayes married on October 14th, 2023?
Yes.
Do you share 2 children with Mr. Hayes?
We have more children, but they're grown. But yes, the 2 minor children is what's left in the home.
Okay, thank you for the clarification. Is there any possibility that you may be pregnant today?
No.
Has there been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Correct.
And do you agree that you and Mr. Hayes should be awarded joint legal, joint physical custody of your children?
Yes.
And do you agree that parenting time should be reasonable and liberal and arranged between the parties?
Correct.
And do you think that agreement is in the best interest of your children?
Yes.
Do you agree that the child support order dated April 4th, 2024 should remain in effect except for the start date should be July 1st instead of February 1st?
Correct.
And do you agree that each of you should keep the property and debt currently held by you keep it to yourself?
Yes.
And do you understand that you'll be awarded the home free and clear
Yes.
and that you will be responsible for any debt related to it?
Correct.
And the property division terms that I just mentioned related to you each keeping your own property and you getting the home. You understand that that is a final property division?
Yes.
And as part of the agreement, you will be awarded immediate exclusive use of the home, meaning that Mr. Hayes cannot go to it.
Correct.
And we are furthermore explicitly stating that both parties are prohibited from entering onto the property where the other party lives.
Correct.
And you agree that you will not receive spousal support, formerly known as alimony.
Correct.
And Mr. Hayes will not receive spousal support from you.
Correct.
And that neither of you can request it in the future.
Correct.
Do you believe that this entire agreement is fair and equitable?
Yes, I do.
Would you like to have your maiden name restored?
Yes, please.
And you understand that you have a right to go to trial on all the issues that we've addressed today.
I understand.
And that if we went to trial, the outcome could actually be better for you, it could be worse for you, or it could be about the same.
I understand.
And that by entering into this agreement today, that you are giving up your right to trial on those issues.
Correct.
No further questions, Your Honor.
Thank you, Mr. Guimond. Mr. Hayes currently resides in the property known as Correct.
Correct.
No.
Yeah, that's his. Obviously, referenced that his
Your
mailing
Honor.
address. So, does he still have personal property there? When is he to vacate?
Sir.
Without blowing up this agreement, Your Honor, he has no personal property, and the agreement is for him to immediately vacate.
Right. All right. Okay. But you're still receive your mail at that address, correct, Mr. Hayes? So we can mail a copy of this judgment. Mr.
Yeah.
Guimond can mail us to any correspondence to us. Maybe get your mail from.
Your Honor, we should change that address. He's been staying with relatives, and I don't want him going back to that address for mail.
Okay. Mr. Hayes, where do you want the judgment voice mailed to you at?
I don't know where this guy is getting all this information from. But I was staying there until we came upon this agreement this morning. So for me to just tell you some address, I have no address as of right now, personally.
He has a relative where he could pick up the mail.
So why are you interrupting me?
So, Mr. Hayes, do you have clothing in the house in the 475 Riverview?
Yes, I do.
Okay, when can you remove those? Or can Miss Emily can box them up, put them on the porch?
Immediately. Yeah, that's fine.
Okay, so other than some, Miss Emily can pack up his clothing today?
Yes.
Sir,
That's fine.
Okay, so you'll pack up the clothing today, and Mr. Hayes, you'll come over. You're not going to enter the home, but you'll simply retrieve your box up personal effects and clothing, correct?
Yes, yes.
Okay, well, later on, what, this evening, tomorrow morning?
Yeah,
when are you going to do that? I'm sorry.
As soon as I get off work.
Okay, so this evening then.
Yes.
But you're not to enter the home. You understand that?
Yes, that's no problem.
Okay. Again, you want this judgment mailed to you, and I guess once you can't go over there. Not going to be divorced. Just give us a different address where we can mail this judgment.
Well, I have to. Can you mail that judgment to that address today? And after that, I'll find the address within the next day or so. You know, because I have to call somebody and ask them what's the address. Pardon me.
The court suggests call your relative and then call back Mr. Guimond and advise him of the new address to which the judgment can be mailed. You go to the postal service to change the forwarding address.
Okay, that's fine.
So you're going to call Mr. Guimond later today and
that's
tell him
fine.
the new address?
Your Honor.
Yes.
I
don't want to talk to him.
I understand that, which is why I'm going to suggest that Mr. Hayes give us the address of a relative right now on the record.
Do you know the address, Mr. Hayes?
I just told I don't have an address right off the top of my head.
Your Honor, he hasn't slept at the home in several months. He's been staying with relatives.
Right. Mr. Guimond, if he doesn't want to
Excuse me,
talk to you, does the secretary can leave his message with you? Or can he email you the address?
I just left the house this morning. Mr. Goldberg, you don't know what you're talking about.
I have no faith that Mr. Hayes is going to comply with that, and I'm concerned about service requirements.
All right. We'll put you in a breakout room. And once you hang up, Mr. Guimond, call and get the address, and then Zoom back in. And you can provide then on the record and Mr. Guimond with the mailing address. Mr. Walker has appeared. Mr. Walker?
This will help her out at all, but the front of the court does have a mailing address for Mr. Hayes that has not been returned as a bad address. So I don't know if that's if it's valid or not, but I can give the court that if you would like.
Please, what address do you have on file?
And in the file, we have 1154162.
All right, so Mr. Hayes, does that address sound familiar? Is that a good mailing address? If you get your judgment voicemail there?
Actually, no, it's not good, but you can mail it there. And as soon as I get off work, I go down to the post office and I get a forwarding address. By that time, that'll give me enough time. As soon as I get off the phone, I'll call my sister or somebody and I'll get their address and I get it forwarded to the other address. So that's fine. No problem.
Right. So Mr. Guimond, you can mail the judgment of divorce to Mr. Hayes at 115.
Very good, Your Honor. Thank you.
All right. So Mr. Guimond's going to prepare this judgment and mail. He submit that to the court. Mr. Hayes, you submit that under the 7-day rule, Mr. Guimond?
Of course, Your Honor.
All right. So Mr. Guimond's going to prepare a written judgment of divorce. Mr. Hayes, along, he's going to mail that to you at this address. So look for it. And there'll be a notice attached to it saying that this judgment will be submitted to the court for signature unless there's a written objection within 7 days. The only basis for an objection on your part is if something's in the judgment you never talked about, never agreed to. So, and if everything's fine, then no action is necessary on your part, and you'll be mailed a copy once it's been signed by the court. Any other questions, Mr. Hayes?
Excuse me, Your Honor. Yeah. How about is it a way that I could just come down there after work and sign the paper from your secretary?
The court does not prepare that. Mr. Guimond prepares it, and you don't want any contact with Mr. Guimond. So I don't know how you're going to go to his office to sign it. Mr. Guimond, is there a receptionist in your office? He could secure the judgment from the receptionist and sign it?
Theoretically, Your Honor, I'm not going to be able to have that prepared by the end of the day. I think it's more convenient to submit it on a 7-day rule.
All right.
That's fine.
All right. So it'll be mailed to you, Mr. Hayes, at the North Macomb Street address. Thank you, Mr. Walker. In any event, the court would like to acknowledge Mr. Walker for his assistance in facilitating resolution of this matter, as well as Attorney Guimond. The court would applaud you, Mr. Hayes, for reaching your own agreement. Obviously, you brought a number of children into this world, and you've done great as parents. You're the oldest, the minors are 17 and 15. So obviously you've done something right. And obviously you'll always be tied together in life because of the children. But in any event, based upon the testimony that's been presented this morning, as well as the claim filed in this case, court finds that jurisdiction has been established. Did we establish the proofs? No. Okay. Court further finds that there has been a breakdown of the marriage relationship to the extent that the opposite matrimony has been destroyed. There's no reasonable likelihood that the marriage can be preserved. According upon receipt of the proposed judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved. The judgment shall enter granting a divorce from the bonds of matrimony. Very well. That will conclude the hearing. You can both zoom out. Have a good rest of the day. Thank you, Mr. Guimond.
Thank you.
All right. Thank you. For the record, Mr. Thompson is appearing via Zoom from the Monroe County Jail. have been arrested on a bench warrant over the last 24 hours. Also appearing is Merrill County Front of the Attorney Rebecca Hicks. Good afternoon, Ms. Hicks.
Good afternoon, Your Honor.
Mr. Thompson, are you being held in jail on any criminal charges?
No. I got a PR bond for unpaid. I was here for unpaid fines was my bench warrant, but I just got out of prison on the 18th, so I haven't been able to pay anything. I've been gone.
Well, what's your current mailing address?
1350.
Okay. How long have you been out of prison?
I got out on the 18th.
Of what month? What year?
This one.
Well, it's only the
24th,
third day of May, so it could have been this month.
Well, last month. Sorry.
All right.
April.
So you got out mid-April.
Yeah. Yes, sir.
Okay. Are you currently employed?
No, sir. Not yet.
Okay. How do you support yourself?
I've been having help now from my mom and stuff. That's what I'm staying with until I can get back on my feet.
All right. So any future notices can be mailed to you at that address. Is that correct?
Yes, sir. They can go there.
All right. And when you get out of jail, you need to come over to the front of the court and fill out a form with providing and writing your new mailing address. Okay.
Okay.
All right, Ms. Hicks, can you give the court a little background information regarding Mr. Thompson?
Certainly, Your Honor. This is an arrears only case. The current balance is $12,813.09. We last received a payment in August of 2023 from an income withholding notice. I will note that he does have a previous finding of contempt. It is from May 3rd of 2017. October of last year, you sentenced him to serve the remaining 18 days or 16 days that were remaining on that first finding of contempt, Your Honor.
So, Mr. Thompson, you were employed in August of 2023, 6 months ago, right?
August, I believe so. I was at Olive Garden because I got out of prison and I worked at Olive Garden for about a month, and then they violated my parole for an assault charge out of here. And then when I seen you guys in October, that's when I got sent to prison, because after I seen you guys, I got my assault violation and went back to Ohio.
Okay. Are you currently on parole?
No, I just finished out my parole time doing that violation.
Okay. And you've been released by district court on a PR bond to come back on a future date to pay your fines and costs. Is that correct?
Yes, sir.
All right. Right. You really got to be focused on securing employment, Mr. Thompson. You have 12,000 rearages, and if you don't start to quickly reduce those, the state attorney general may very well charge you with a felony charge of felony non-support, which you go back to prison.
Yeah.
Ms. Hicks, what's your recommendation this afternoon, Ms. Hicks?
Your Honor, because he's recently been released from prison, the friend of the court would simply like to cancel our bench warrant for him now and set an adjourn date so we can give him the opportunity to try and get gainful employment now that he has completed his prison sentence. So at this time, the friend of the court would like to adjourn this over to June 18th at 8 a.m.
Docket?
On my docket.
All right. All right. So, Mr. Thompson, do you understand all of that?
Yes, sir.
All right. The court's going to authorize you. I'm going to cancel your bench warrant. You can be released on a personal bond. You'll be processed released this afternoon. Before you head home, you walk across the street to the front of the court, to the ground floor of the building, and fill out a change of address form with your mom's address in writing. So that way they can mail you a copy of this notice. You got to appear before Ms. Hicks on June 18th at 8 a.m. You can appear via Zoom if you're working. What we're hoping is that you will have secured a job and you need to make some payments between now and then. You've got a couple months.
Yeah, I have a job set up through my brother that I just turned an application in for. They're supposed to be able to accept it, so that should be here soon.
Okay, you got 6 weeks to make a payment, Mr. Thompson, so make it happen. And then appear on June 18th. You can avoid another bench warrant. Any questions?
Yes. No, sir.
So don't wait for your brother, or whatever. Just take whatever you can find. Okay?
Yes, sir.
All right, anything further, Ms. Hicks?
Nothing further on this matter, Your Honor.
All right, thank you. Mr. Thompson, you can step out.
Thank you.
Welcome. You are Michael Tuminello, is that correct?
Yes, sir.
All right, Mr. Tuminello is appearing from the Monroe County Jail, having been arrested on a bench warrant issued at the request of the Monroe County Front of the Court. This hearing is being conducted via Zoom. Also present is Monroe County Front of the Attorney Rebecca Hicks. Mr. Tuminello, are you being held on any criminal charges today?
No.
Okay. Ms. Hicks, can you provide the court with, first of all, why don't you give us your mailing address, Mr. Tuminello?
6.
Okay, that's the address we appear to have on the file. Ms. Hicks, can you provide the court with some background information regarding Mr. Tuminello?
Certainly, Your Honor. In this matter, there is a current monthly support obligation of $235 a month. There is a current arrears balance of $5,632.16. The last payment received was May 16th of 2023 from income withholding. There is no previous finding of contempt at this time. It looks like the respondent failed to appear at a referee show cause hearing in October of 2023 where a bench warrant was recommended, and it went on lien in November of 2023.
Thank you. You're asking the court to commence contempt proceedings, is that correct?
That is correct, Your Honor.
All right, Mr. Tuminello, do you understand you're being charged with civil contempt of court for failure to pay child support? It's punishable by up to 45 days in jail. Since there is possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. You understand that?
Yes, I do, but I have 2 jobs now, and I also have a job that I work back at Applebee's, so that way you guys could start pulling the money out that you were pulling it out that time previously. So I made sure to get that job back so you can pull the money back out weekly. I haven't got paid from them yet, but I just started not even a week ago.
All right. Well, Mr. Tuminello, you should have, first of all, I've been sitting on your hands. You didn't appear when you mailed the notice last fall. You've not come in to front of the court and asked for a motion to reduce your support. You've not kept the front of the court informed of what's going on in your life. So that's all good that you got a job. Hopefully you'll get that have a job when you're out of jail. The court's going to require you to post a cash bond. In any event, I need to ask you a few questions. I'll appoint an attorney to represent you. Currently, you're employed, but you've not received a paycheck, correct?
No, I have. I work 2 jobs now. I work at Meyer Warehouse and I work at Applebee's.
Okay.
I did that
When
so
were
I
you
could
last
pay
paid?
this. I just got my first pay from FHI, which is Meyer Warehouse, last night, which is somewhere in my property, and I just got paid from Applebee's, I think like not even a whole week ago. That's what I was saying. And
So
I
how
wasn't
much
able
did
to
you have?
contact the court because there was no internet at the place that I was staying at. There was no way for me to contact anybody with anything. I didn't have a phone. Mine got broken and there was no internet where I was staying. So there was no way for me to contact anybody.
You could come down to the Monroe County Courthouse and meet at the front of the court.
You're right. And that is on me and I apologize, but I am trying to make it right. You can ask my kid's mom. I talk to my kids every single day. I get them anything they need. I know it doesn't count because you guys aren't involved or whatever, but it's a fact and it's true. So I do take care of my kids and I'm there every single day.
How much, but you're not supporting your children. That's the reality. You got to pay through the
Well,
front
I'm
of the
not
court. You don't
supporting
pay
them
to
through
the
you
mother of the
guys,
child.
but
You don't pay
they
to the
get money
children.
from me
You
every
pay to
day.
the Monroe County Front of the Court.
Right. See,
How
I
much
know,
money
and I
do you
know
have
it
in your
doesn't
property?
count.
Mr. Tuminello, how much money do you have in your property? You're pushing the court. Just answer the questions, please.
I think it's $200, $200 and something dollars. I didn't get a chance to fully look when I got brought in last night. I didn't get to like fully look. I know it's 200 something. And then I'm
Is it
at
cash?
home. I have a card that's got it's on a debit card. And then at home, I got another $244 on another debit card that's just sitting on my window ledge. I forgot to grab it on my way out yesterday, and I knew I should have.
Do you have cash in your property, or is it just a paycheck or a card?
No, it's a debit card. It's a Chime
Right.
debit card, and I have $25 cash too.
Okay, so how long have you worked at Meyer Warehouse?
This will be my 2nd week. I get paid weekly from them. I was supposed to be there at 3:45 this morning.
How long have you worked at Applebee's?
4 years. You can look back that's where you guys been pulling money out from me this whole time before it
Right.
stopped. And then I wasn't working there, but I'm back there so that way you guys could.
All right, the court at this time will grant your request for an attorney. Provide the court with a phone number that the attorney can reach you at, Mr. Tuminello. Do you have a phone?
I finally just got one. Yes.
What's the number? It's too late in the day to have an attorney appointed to represent you. It's now 1:45 in the afternoon, Mr. Tuminello, so the court's going to schedule this for Monday, May 6th, 11:15 a.m. You ordered to personally appear in Judge Bronx Court, 4th floor of the Morgan County Courthouse. That's Monday, May 6th, right around the corner. And unfortunately, the reality is you need to reach out to someone to post a bond on your behalf, and when we get out, you can pay them back. So the court's going to require that you post a $500 bond in order to be released between now and Monday.
Wait, please, listen. Can we do like a 300, 250? That's all I have on me till I get home. No one is around me that has money. They can't even pay their internet. Please, I'm begging you. I will give you the money right now. I have it right there. I'll give it to you right now. It's literally, I'm looking at property. Please.
Sir,
I'm sorry.
you said you have a card. Please. You don't have any cash, so you can't, can't post that until you get out of jail.
I understand that, but no one I know has money. That's why I work 2 jobs, because no one, listen, please. I'm not running. I'm not going nowhere. I will take one of your officers and go get money off the ATM, whatever it takes. Please. No one I know has money is going to do that for me. Nobody. And I cannot afford to lose these 2 jobs, or I won't be able to pay my child support from here on out. It took me forever to get these jobs. Please, I'm begging you. Please. I'm sorry. Please.
What's your opinion? Please. Tell me you've ignored this for over a year.
Please.
You've not made payments since May of 2023. It's now May of 2024. You've not had any contact with the front of the court. You've blown everything off. Ms. Hicks, what's your thoughts?
And I promise you that'll never happen again. If I ever mess up again, lock me away and throw away the key. I promise.
Mr.
It's never going to happen.
Mr. Tuminello, how much cash can you get together
today? At least
or tomorrow or Sunday. If you want to be released, the courts will require some type of cash bond. So if you can post maybe $300, the court
cash
will
today, I can come up with at least $400. I have to be outside to get out of my house. No one's going to get it from me, and no one knows the pins. No one's going to do all these things for me. They've already proven they won't help me. That's why I have to do it.
So you can't come up with even $300 cash. Is that correct?
Yes, not cash. I have it on a debit card. I just got to pull it off an ATM. It's just a regular debit card.
Unfortunately, it does not work that way, Mr. Tuminello. Ms. Hicks, your thoughts? Any input?
Please.
The friend of the court will leave it in the court's discretion, Your Honor.
Has Mr. Tuminello had a history of failing to appear?
Let me check, Your Honor.
I have not been staying at that house. I was not around them people for the last over a year. I didn't know. No one told me I got mail, and I apologize. But as soon as I found out, I came and got 2 jobs and got that job back so you guys could take the money out. I apologize for my absence. You can ask my kid's mom. I'm there every single day, answer every call, and help them with everything.
But we don't need you to
even
apologize.
Though it's not
we just want you to take care of the business. Ms. Hicks,
I know, and I'm always about that.
Failing to appear.
Your Honor, this is the first. Mr. Tuminello, please stop. Your Honor, this is the first bench warrant that has been issued for Mr. Tuminello for failing to appear at a show cause hearing. Prior to the last payment in May of 2023, he was consistently employed, and we were getting payment for quite a few months consistently from his previous employer. However, we have not had contact with him in the past year, but this is the only bench warrant that has been issued for him in this case.
All right, Mr. Tuminello, I'm going to give you the benefit of the doubt. I'm going to authorize release on a personal bond. So be process released today, but you need to appear Monday at 11:15. Your attorney will call you by phone, and I'm telling you, you need to bring $500 cash with you on Monday. If not, bring your toothbrush, because you'll be buying yourself some jail.
Okay, no problem at all. Thank you so much.
$500 cash.
Thank you.
Minimum on Monday, 11:15. So when you come into the courthouse, you stop in front of the court, pay the $500, and you bring your receipt up here, the 4th floor, and we'll go on the record at 11:15. So I'm going to give you the benefit out. If you don't appear, bench warrant's going to issue, and you're going to be we're going to send the dogs after you, Mr. Tuminello. So make sure you appear on Monday.
Okay.
I'm giving you.
I will be there Monday. Thank you so much. Thank you. I appreciate it. Thank you.
Don't let us down.
I won't. I promise I won't.
Anything further, Ms. Hicks?
Nothing further, Your Honor. I'm preparing those orders, and I'll have them uploaded to your queue.
Thank you. All right, Mr. Tuminello, you can step out.
Thank you so much. Thank you.
Susan Sword versus Ethan Sword. This matter is before the court for a pretrial conference. The same is being conducted via Zoom, and appears both parties are present. Susan and Ethan, good afternoon.
Hi.
Good afternoon.
Susan, we didn't pick up your response. Can you hear the court?
Yes, I can hear you. Can you hear me?
Yes, much better. So the court's in receipt of a two-page consent judgment. Both of you have signed, but it's blank. You didn't fill any of the blanks in.
The paperwork that I had mailed to me, it looked like we were just supposed to sign the bottom of it. I didn't know there was some check boxes, but I had already checked those with the original paperwork. I didn't know if you had to do that or we did.
Oh,
I apologize.
that was the complaint, but you need to complete this. But what I could do is I could walk through this with both of you, and I can fill in the blanks, and I'll put the box that I check. I'll put my initials next to it. Okay.
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 All right. All right. Can you both please raise your right hand to be sworn?
7.
Thank you. Is it true, ma'am, that you filed a complaint for divorce with this court on about February 20th, 2024?
Yes, sir.
Is it further true that on the date you filed that complaint that you've been a resident of the county of Monroe for at least 10 days and the state of Michigan at least 6 months?
Yes, sir.
Is it further true that you married Ethan Sword on November 11th, 2011, and you separated in April of 2023?
That's correct.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects can match when you've been destroyed?
That's correct.
Is there any chance of reconciliation?
No.
Were there any children born or adopted during your marriage who are still minors?
No.
Are you currently pregnant?
No.
And you signed your name to this proposed judgment, correct?
Yes.
Okay. Mr. Ethan, can you please state your name and address for the record? And this reflects an address of Willow Street, but it appears probably you moved to Cleveland. Is that correct?
Yes.
So what is your, state your name and your current mailing address?
My name is Ethan
All right,
Sword.
Mr.
I'm
Sword,
sorry
did you
about
hear the
that.
testimony? That's fine. Did you hear the testimony this afternoon of your wife, Susan?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes, sir.
And you also signed your name to this proposed judgment. Is that correct?
Yes, sir.
Okay, I'm going to walk through these terms with you. The first item to be checked is spousal support, from known as alimony. And presumably you agree that spousal support is not awarded and that's forever barred. Is that correct? You both appear to be young.
Yes.
Susan, would you agree spousal support is not awarded and that's forever barred?
That's correct.
Okay, I'm going to check that box. Neither party's awarded spousal support, and the spousal support is forever barred. Put my initials next to that. Next, it deals with personal property. Have you already divided your personal property?
Yes.
Yes.
So I'll check the box. Each party is awarded the personal property current in his or her possession and pay any debt thereon, and that's a possession of personal property is awarded free and clear of any claim on the part of the other. I'll put my initials next to that box. Next is debts. Are there any joint debts that need to be addressed?
No.
Okay, so each will pay any debts. There are no debts to be divided. Each pay any debts in his or her own name. Next is motor vehicles. Is it true that each will keep their own automobile free and clear of any claim on the part of the other?
That's correct.
Yes. That's correct.
Okay, I'll check that box. Next is real property. Do you own real property that needs to be divided?
No, we
No.
don't.
Okay, so I'll check the box that you do not own real property. Next, it deals with retirement benefits. Will each keep your own, whether it's an IRA or 401k or pension, each will keep their own free and clear of any claim on the part of the other?
Yes.
Yes.
Okay, I'll check that box. Each party is awarded his or her own pension, annuities, IRAs, or other type of retirement plans, free and clear of any claim on the part of the other. Lastly, Ms. Sword, are you requesting a restoration of your former name or are you going to keep the name Sword?
I'm going to keep my name.
Okay.
Sword, yeah.
There's a space in this judgment to change your name if you chose to do so, but you're choosing not to do so, so it'll remain Sword. Okay, that appears to address everything. Okay, so that appears to cover everything. The court has filled out the judgment. I put initials next to that. Ms. Susan, do you have any questions for the court?
Nope, I don't.
All right, Mr. Ethan, do you have any questions for the court?
No, sir.
Okay. Based upon the testimony that's been presented this afternoon, as well as claim file this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown relationship to the extent that the obviously matrimony had been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved and judgment shall enter, granting a divorce from bonds of matrimony. Court will sign the judgment. You both will mail a copy of this judgment, and that will conclude this matter. You can both zoom out. Have a good rest of the day.
Thank you.
You.
You're welcome. President, the court's in receipt of a proposed consent judgment, which with both of you have completed. One item needs to be addressed before we begin. That is a filing fee. Michael, when you filed this, you indicated you're in public assistance. You still receive public assistance.
Yes, I do, Your Honor.
Okay. The taxpayer should have to pay this filing fee. Miss Bambi, are you in public assistance?
What was that?
Do you receive public assistance?
Yes.
Okay. You both could be young. What kind of public assistance?
Insurance and food stamps.
Okay. Mr. Lyman, what kind of public assistance do you receive?
Your Honor, I receive housing assistance, food benefits, Medicare and medical assistance. But I am willing, if it pleases the court, to make some arrangements to pay the filing fee if that is needed.
It's $175, and I can give you as much time as you need in which to pay that.
I'd be willing to make monthly payments, Your Honor, if that's allowable.
Yeah, the clerk will not accept monthly payments. They only accept a lump sum, so you need to maybe put some money aside every month, and you got to pay it one lump sum. You can pay by credit card, but they will charge you a fee. You're best off just paying $175 cash. You can avoid a 3% or 4% to credit card fee.
Yes, Your Honor, that's fine. I'd be happy to pay that as soon as possible.
So do you need the end of May, or do you want the end of June to do that?
Let's do the end of June, please.
Okay, so what I'm going to do is I'm going to write in page 2 of the judgment that the plaintiff, Mike, will pay the $175 filing fee on report June 28th. It's the last Friday in June, okay?
Yes, sir.
I'm going to write down the judgment. I'll put my initials next to that. Mr. Lyman, if in fact you can't pay that, you call the court and I'll give you an additional month or 2 months. I will work with you. Just don't blow it off. You blow it off, that's what bench warrants issue. We don't want that to happen. So please, if you can't pay on June 28th, call the court and say, Judge, I need another month, and I will give you another month, okay?
Yes, sir. Absolutely.
So
I'm going to try to pay it before that if I can.
Okay, and you go to the Monroe County Clerk, same place where you filed your divorce complaint.
Okay.
So I'm going to write in here, is to not put my initials next to that language in the judgment. All right, Mr. and Mr. Lyman, can you both please raise your right hand to be sworn, please? Do you both solemnly swear? Raise your right hand, please. Do you solemnly swear affirm that the test? I'm sorry, go ahead, ma'am.
I just said yes, sir.
Okay. Do you both solemnly swear affirm that the testimony about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Judge.
Yes, sir.
Thank you. We'll start with you, Mr. Lyman. Can you please state your name and current mailing address for the record, please?
My name is Michael Scott Lyman.
Thank you. Mr. Lyman, is it true that you filed the complaint for divorce with this court on about February 2nd, 2024?
Yes, Your Honor, that is correct.
Is it further true that on the date you filed that complaint, you've been a resident of the County of Monroe for at least 10 days and state of Michigan at least 6 months?
Yes, Your Honor.
Is it further true that you married Bambi Harrell, now known as Lyman, on July 20th, 2013? You separated in April of 2022.
Yes, Your Honor.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects in matrimony have been destroyed?
Yes, Your Honor, that's correct.
Is there any chance of reconciliation?
Not at this point, Your Honor, no.
Were there any children born or adopted during your marriage who are still minors?
No, Your Honor.
Lastly, is it true, sir, that you signed your name to this proposed judgment approving the terms and conditions contained therein?
Yes, I do.
All right. Ms. Bambi, could you please state your name and mailing address for the record?
Bambi Vanessa
Thank
Lyman.
you. Ms. Lyman, did you hear the testimony of your husband, Michael, this afternoon?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Did you sign your name to this proposed judgment approving the terms and conditions? Is testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Did you sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
I'm going to walk through the terms of judgment with both of you, so listen carefully. You've agreed that spousal support is not awarded. That's forever barred. You've already divided your personal property, so this provides that each is awarded the personal property currently in your respective possession, free and clear of any claim on the part of the other. There are no joint debts, so each paying debts in their own names. Each will keep their own automobiles, free and clear of any claim on the part of the other. There's no real estate to be divided, and there are no pensions or retirement plans to be divided. Finally, Ms. Lyman is requesting restoration of the former name of McElvenna. That's it. Mr. Lyman, do you have any questions for the court?
No, Your Honor. Yes, I'm sorry. Does the completion of the divorce proceedings, does that wait until after the $175 is paid, or does that happen and then I have time to pay?
The court's going to sign that judgment today. You'll be divorced today.
Okay, very good, Your Honor. Thank you.
Waiting in the judgment, in terms of judgment, ordering you to pay the $175 on or before June 28th, 2024.
Yes, sir. Thank you.
Again, just don't blow it off. If you need more time, you call the court and we'll give you more time. And it's paid at the Monroe County Clerk's office, second floor, and they will only take, it's got to be a lump sum. They won't take partial or installment payments. Okay.
Yes, Your Honor. I'm going to take care of that as fast as possible.
Thank you. Ms. Lyman, do you have any questions for the court?
Not really, as long as there isn't anything I need to do in order to switch my name back, other than like just get my ID and all that.
Well, there is. Once you get a copy of the judgment divorce in the mail, you'll receive it next week in the mail. You need to take a copy to the Secretary of State and Social Security to facilitate the legal change of your last name. But it's provided for in this judgment. You need to take the judgment to those two offices, Social Security and Secretary of State. Okay.
Okay.
And that's all you need to do. All right, you're welcome. All right, based upon the testimony that's been presented this afternoon, as well as complaint filed this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved, and judgment shall enter, rendering a divorce from bonds of matrimony. Court has signed the judgment. Good luck to both of you. Now we'll conclude this hearing. You can both zoom out. Have a good rest of the day.
Thank you, Your Honor, for your time today.
You're welcome.
Thank you.
Can we just hang out?
Yes, you can hang up.
Oh, thank you. Bye.
Welcome. I think the court will recall the matter of Brittany Guimond versus Cody Guimond. Brittany Guimond is appearing via Zoom for this pretrial conference this afternoon. Miss Brittany, you did make contact with Cody then?
Somebody using Cody's Facebook Messenger. Apparently she currently cannot talk. So I let them know that she was supposed to be in court with me today to finalize everything, and I have not received anything back from them since. I've called 4 or 5 different times. I fear that it's what you said, and I'm going to have to file a default and get another hearing.
Correct. So you don't know who's messaging you?
No, sir.
Ask who is this? Can someone, if it's not Cody, can you reach out to Cody and give her the Zoom ID number? I mean, I don't know, is she in the hospital right now?
I have no idea where she's at. I can send the Zoom ID number. I can try and get her here, but they haven't even replied to me yet. So let me.
Today, it's not going to be finalized. If she came here and she said, we got to talk about debts, you're going to talk in front of the court trying to mediate through this. So you try to reach agreement. So you're not going to, no one's going to get divorced today, but she's got to participate. If in fact she wants to address these debts, then she's got to appear.
It looks like they just read what I said. I sent the Zoom meeting ID, so hopefully.
Did you try texting?
Yes, sir.
Okay, and no response to the text?
No response. Apparently she is on her way to the hospital.
Okay, and this is what, a third party telling you that?
Yes, sir.
Is that correct?
Yes, sir.
Right, okay. All right, so this is what the court's gonna do, Ms. Guimond. Again, I think you need to reach out to her, get her to participate. The court is going to mail you a copy of her letter, her answer to this divorce complaint. I'm also gonna mail back to you your judgment divorce you sent here, because she needs to review and sign this. So you need to hold on to it, you got agreement so you can complete that. And the court will also enter a default. She should have appeared today. She could have appeared 20 minutes ago before she left for the hospital. Just tell the court that she's hospitalized. So the court will enter a default for a failure to appear. And I'm going to mail this and I'm going to schedule for another hearing for the morning of May 30th. It's a Thursday morning. We either have 8:30 or 9:30. Are you available at 8:30 in the morning?
Yes, sir.
I'm sorry.
Yes.
Okay, sometimes we're getting your response, sometimes we're not. So the court mail notice to you, you've got a confidential mailing address, but obviously my office must know what that is because you received a copy of this notice to appear, correct?
Yes.
Okay, yep, we got an address for you. Still here in Monroe, correct?
Yes.
Right, we'll mail you notice to appear, and it'll be again a Zoom hearing Thursday, May 30th, 8:30 in the morning. We're going to send a copy of the notice to appear to Cody. Hopefully she'll appear. Court will also enter default. We'll mail you a copy of default. What you need to do is this proposed judge we're going to return to you need to mail a copy of that to Cody and make instructions. Along with, you need to submit a notice of entry. You can go online and find that form, notice of entry of judgment, and give her notice saying to Cody Guimond. You need to mail it to both addresses. Please take notice that the enclosed proposed default judgment divorce will be submitted to Judge Braunlich for entry on May 30th, 2024, 8:30 a.m. So if she does not appear at that time, the court will sign the judgment. So, but if in fact it says each repeating debts in their own names, if in fact she sees that and she wants to contest it, hopefully they'll give her the incentive to appear that day. If so, then the court will allow her to address how that debt should be divided.
Yes, sir.
Any questions?
No, sir.
So again, you need to prepare a notice of entry to judgment, form her that on May 30th, 2024, 8:30 a.m. via Zoom. You got to include the Zoom ID number that you will present to the court for entry, the closed proposed judgment. So you're going to be mailing her a notice of entry as well as a proposed judgment. If you got that together, we can get you divorced on that day if she fails to appear again. Okay.
Yes, sir.
Okay, you can zoom out. That'll conclude this matter. We'll see you then on May 30th, 8:30.
Thank you.
You can hang up. Being conducted via Zoom. The plaintiff, Brittany Guimond, is present. Ms. Guimond, we didn't hear from you, so we're tracking you down again. Spending a lot of time necessarily trying to help you. And the courts and the staff have asked you to zoom back in. Okay, what else of your efforts to get Cody Guimond here? Can you buy her breakfast? Can you send her $20 to get her to appear?
I told her that I was zooming back in with you. She told me that if she has service that she would be zooming in with you. I told her exactly when. I told her the ID number that she needed.
Okay, where's she at? She's out west right now?
Yes.
Where?
She was in Montana.
Okay, if she doesn't have a Zoom, we can give her a phone number. She can call in up here by audio. We're going to give you a phone number. So you can this is not an office phone number. This is a Zoom phone number. She can actually appear with you here in open court, but on audio rather than calling my secretary's phone.
No, is it the 646 number, Your Honor?
Yes. Yeah. So if she doesn't have internet, she can call.
That's what I told her, Your Honor.
Okay. So why can't she call? Why you got to help us here, Ms. Guimond.
I don't know. I've been pushing her. She told me if she had service, she would call.
Well, is she traveling right now? Is she on the road?
From what she said, yes.
Okay. Well, she had service when you called her. Why don't you say, let's call right now?
I did.
She asked that service when you talked to her.
She was texting with me.
Okay. All right. Why don't you try calling her right now? And you're gonna see maybe she can appear through your phone. Call right now, see whether she has service, whether she'll answer the phone. Tell her you're talking, you're in front of the judge right now. Let's ring her, see whether she will answer.
She's not answering me.
Ms. Guimond, the judgment divorce that the court has in its possession, did Cody return it to you or did Cody mail it directly to the court?
Cody mailed it back to the court.
Okay, so you've not seen it then, correct?
I have not.
You can't tell whether it's her signature or not?
Not from this far away, no. If I was there in person, I'd be able to.
All right, do you have any objection to, do you have any objection to court dismissing this matter? Can require you to refile. You need to help out the court, or you need to refile this, ma'am. The court, I can only do so much to help you.
I can refile, that's fine.
Of course, then you got ever served again. You're trying to track her down out west. It would seem like it'd be really simple if you just get her to appear for 30 seconds. I don't know what more I can do.
I'll refile, thank you.
I'm sorry?
I can refile. She's not answering me. She's not getting on the Zoom. I don't know what else to do.
But you understand she's out west somewhere. How are you going to find her to serve her?
She's just supposed to be out. She's on her way back to Michigan right now. Apparently, she was on some type of retreat.
Okay. When will she be back in Michigan? Will she be back in Michigan next week? We'd put this off for a week.
I'm not sure. Probably within the next couple days.
So did you actually talk to her today?
Yes, I did.
Okay, so she's en route back from Montana back to Michigan. That's what she told you? She'll be back in a couple days?
Yes.
Okay. Do you think she will appear if she's has service?
I'm hoping.
Okay. Well,
Told me if she had service, she would appear.
okay. Well, you know her. I have no idea who she is. You know her. Do you think she's inclined to appear, or is she just playing games with you?
To be honest, I think she's playing games with me.
Okay. Well, because we got from the Postal Service a new address, which is an address in Lansing, but you say she's now in Midland. So where can we can't even mail her a notice?
She sent me Midland.
Okay, but you have no address, so correct? So we can't send her a notice if we have no address.
I do have an address. I just have to find it.
And where'd you get this address?
She gave it to me.
Okay. Court cannot enter a judgment by consent. And I don't know whose signature this is, and I need to verify she's not now pregnant. So you will not get divorced till you get her here. So reach out to her roommates, her family, her friends. She was mailed a notice to appear.
Yes, sir.
I've got a lot of other cases. I can't keep dragging this case out, ma'am. You need to cooperate and assist the court if you want to get divorced. I'm gonna give you the court's phone number. You call her and get her available sometime today or tomorrow. Let's try to do it today. Let's be done with this. She's got to appear. It's gonna take her 2 minutes. And if she doesn't, you've got to jump through some hoops if she's gonna play games with you. Does she have some? What's the issue? What's the problem?
I don't know. She promised me that she was gonna be here, and she's jumping all my calls.
Okay, I don't know what you mean by jumping your call. She's not answering them. Does she have a roommate? Does she have a mother? Does she have a sister? Does she have the next door neighbor you can call and get this message to her?
I can call her siblings, but I don't know how much of a help that they're gonna be.
Well, just if they can reach out to her and say, you got to call, but the court's waiting for you this morning. She's got to appear, give the Zoom ID number. We mailed it to her. Now, we mailed it to her 2 different addresses, one in Saginaw, one in Lansing. Do you know have any idea where she's living?
Yeah, she's up in Midland right now.
Okay, well, obviously you took his judgment to her, right? Or did you mail it to her?
I mailed it to her. I mailed both the judgment and another piece of paper to her, but apparently she didn't mail that other paper back.
Right. All right, so we're going to give you the court's phone number, 734. Your main goal all day today is to get her to respond to you, and then you call the court and let us know when she's available. I will not be available between 11 and 1:30. So I would suggest let's do it this afternoon.
Yes, sir.
I'll be back at 1:30. You call my office, let us know when you're both available. You'll be zooming in and we will be ready for it.
Yes, sir.
So I would think she'd want to get divorced too, or maybe she's opposed to this divorce. So if she's not going to cooperate, you need to jump through hoops. You need to file a motion for a notice for entry of a default judgment. So we'll go through those again. Once again, if she does not appear later today. So we need to hear from you today. If you don't get back to this today, I'm going to dismiss this complaint. You got to start all over again.
Okay.
So please call my office. Let us know when you and she are both available to appear. It'll take 2 minutes. Okay?
Yes, sir.
All right. All right, that you can zoom out. And what is that address?
24242.
All right, we're going to try one more time, Miss Guimond. Maybe you need to drive to Midland.
At this point, I'll try anything.
Okay, well, I mean, do you have any mutual friends
No.
that might be able to reach out to her and convince her to finalize things so you can move on with life? There's nothing really at issue here. We just need her to attest to the fact she's not now pregnant and that she, in fact, signed her name to this judgment. It'll take her less than a minute.
And that's what I told her.
So you're unemployed. You can appear any day. Is that correct?
Correct.
All right. All right. And you're still, we have your confidential mailing address. So we will mail. I don't have a date right now, but we're going to reschedule us for a couple weeks and hopefully she'll be back. Keep in touch with her. This will be the final adjournment. So the court's going to send her out a notice that a default judgment will enter. I'm trying to help you as much as I can, Ms. Guimond. You're still unemployed, is that correct? You're on Social Security disability?
Correct.
Okay. Tell her buy her dinner if she appears, and do what you have to do to make it work, Ms. Guimond, all right?
Yes, sir.
All right, we'll send out notice to you as well as to her. We'll send it to sometime, I think, in early June. All right.
Yes, sir.
We'll give one more try. Keep in touch with her. Try to do what you have to do to convince her to appear.
Okay.
Even if you got to take her to dinner at her favorite restaurant. Okay, all right, you can zoom out.